Welcome to this explainer. Today, we're unpacking a really fascinating procedural puzzle from a 1998 judgment by the Constitutional Court of South Africa. It's a case that forces us to look closely at how the legal profession is regulated, who actually gets to make those rules, and crucially, which court literally has the power to change them.
Okay, let's dive into this. Imagine being suspended from your profession simply because you accepted a client. Crazy, right? Well, that is the exact dilemma that faced Joaquim Augusto de Freitas, an advocate who decided to bypass attorneys and just deal directly with the public. I mean, it sounds pretty straightforward, a lawyer helping a client. But in the South African legal system of the 1990s, this sparked a massive, high-stakes constitutional battle.
So to untangle this dual-pronged legal battle, here is our roadmap. First, a rogue advocate stand. Second, who polices the profession? Third, the controversial referral rule. Fourth, which court decides? And finally, the final verdict.
Let's start with Section 1, a rogue advocate stand, featuring our protagonist, Joaquim Augusto de Freitas.
Just look at this timeline to see how quickly things escalated. In September 1996, the Society of Advocates of Natal went to the High Court to have de Freitas completely struck from the role of advocates. Fast forward to April 1997, and his professional association, the Independent Association of Advocates of South Africa, launched a counter-application to protect him. And by September 1998, this fight had made its way all the way to the absolute highest court in the land, the Constitutional Court.
The High Court's initial ruling was pretty severe. They found de Freitas guilty of unprofessional conduct and suspended him for a full 6 months. His crime? Breaking the so-called referral rule. Basically, he accepted work directly from members of the public without an attorney acting as a middleman. And that suspension was exactly what set the stage for de Freitas to fight back on constitutional grounds.
Moving on to Section 2, who polices the profession? We'll look at Issue 1, the standing argument. So the applicants brought this massive two-pronged attack to the Constitutional Court. Challenge 1 was against Section 7.2 of the Admission of Advocates Act, and Challenge 2 aimed directly at the referral rule itself. Let's tackle that Advocates Act challenge first.
The applicants argued that Section 7.2 was completely unconstitutional. They claimed it basically ignored the constitutional rights of parties threatened with suspension. Why? Well, because Section 7.2 allowed the Society of Advocates to initiate disciplinary proceedings against an advocate who wasn't even one of its members. De Freitas' argument was essentially, I'm not in your club, so how do you have jurisdiction over me?
Now, what's really interesting here is how Deputy President Longa completely dismantled that argument. He pointed out a massive flaw. Standing does not equal jurisdiction. The Act doesn't give the society jurisdiction over non-members. It just gives them the standing to complain. Think about it like this. Literally anyone can report a crime, right? But only a judge actually has the power to sentence you. The disciplinary power rests entirely with the courts, not the society. And since this right to complain existed in common law way before the Act was even written, this first challenge totally fell flat.
That brings us to Section 3, the controversial referral rule, a constitutional challenge.
Let's decode this legal jargon for a second. The referral rule was this long-standing practice that strictly prohibited an advocate from accepting work direct from the public, meaning if you wanted an advocate to represent you, you had to hire an attorney first, and they would refer the work to the advocate. So advocates were essentially forced by this rule to rely exclusively on attorneys to get any clients at all.
And here is the core logic of why the applicants were so furious. Thanks to the recent Right of Appearance in Courts Act, attorneys could suddenly appear in all courts, something that used to be strictly reserved for advocates. So almost overnight, attorneys became their direct competitors. The applicants argued it was incredibly anti-competitive to enforce a rule forcing advocates to rely completely on their literal competitors for business.
They tied this directly to the 1996 Constitution, specifically Section 22, which states every citizen has the right to freely choose their trade, occupation, or profession. For them, being forced to get all your work through a rival basically crushed their constitutional right to practice their profession freely.
Now for the plot twist. Section 4. Which court decides? The jurisdictional twist.
So, the Constitutional Court agreed that testing the referral rule against the Constitution was absolutely a valid constitutional matter. But they pulled the procedural handbrake. It raised a huge question. Both the Constitutional Court and the Supreme Court of Appeal, the SCA, have jurisdiction here. The applicants deliberately bypassed the SCA to come straight to the Con Court to save time and money for the 300 advocates affected. But was skipping the line actually the right move?
To see why this matters, we have to look at the judicial division of labor under the 1996 Constitution. As you can see, the Supreme Court of Appeal is the highest court except in constitutional matters, holding vast expertise in common law and its development. Meanwhile, the Constitutional Court is the final word on direct applications of the Constitution.
And this brilliantly illustrates why the Constitutional Court hit pause. Deputy President Longa quoted Chief Justice Chaskelson from the recent Amote case, stating that when a constitutional matter involves developing the common law, the Constitutional Court shouldn't just act alone. Because the SCA has such deep expertise in common law, the Constitutional Court essentially needs them to weigh in first before making some sweeping constitutional ruling.
So, bring that back to Freitas. The referral rule isn't actually written in a statute book anywhere. It's entirely a matter of common law and long-standing practice. And because regulating the legal profession falls squarely under the traditional, inherent jurisdiction of the Supreme Court of Appeal, the Constitutional Court basically said, look, you've got a valid argument, but you are in the wrong room. You have to go to the SCA first.
Finally, let's wrap up with Section 5, the final verdict, costs and ticking clocks.
The final order was crystal clear. The application to appeal directly to the Constitutional Court was refused. But notice what's missing here. They didn't rule on the merits. They didn't say if Freitas was actually right or wrong about the referral rule being unconstitutional. They just flat out refused to hear it directly.
Which brings us to the most important number in this entire judgment, 1. The court put Freitas and his association on a strict 1-month ticking clock. They had exactly 1 month to initiate proceedings in the correct court, the SCA.
And the financial stakes of that 1-month deadline were astronomical. The court said if they appealed in time, the cost would be decided later. But if they gave up or missed the deadline, they would have to foot the entire legal bill for dragging everyone to the wrong court in the first place, including paying for the respondents to counsel. Talk about pressure. So we are left with a fascinating procedural end to a really substantive dispute. And it leaves us with this huge question. Should the traditional rules of common law evolve to allow advocates direct access to the public to foster competition, or is that referral rule and the strict separation of attorneys and advocates an absolutely essential pillar for a functioning legal system? Really makes you think, doesn't it? Thanks for joining this explainer, and we'll see you next time as we keep mapping out the complexities of the law.